And welcome back into Open Line. So glad that you're watching here on News Channel 5+. Chuck along here with Kevin Kennedy from the Kennedy Law Firm. I tell you, one of the very top law firms in the entire state of Tennessee, in business over 35 years. Kevin and I talk about this often, but experience matters. And when you are dealing with so many different types of situations legally, you need a law firm that has that kind of experience. And 35 years, you can't beat that.
One of the things I can sense now, as a young lawyer, I would hear those circumstances, and then I want to run talk to an older lawyer. That was my natural. Even now, I can cut through the chase. I got the issues right that we talked about during the break. Years ago, a show like this was not available. So I want to encourage the parents and grandparents, take some notes and teach your children. It'll be invaluable, because once we're caught in a jam, it's bad. How do we get, so what we're teaching is how to avoid some of these jams.
That's exactly right. And we do appreciate so many of you calling in. We appreciate your patience. We are going to get to as many calls as we can in this half hour, our last half hour, so do get online with us as soon as you can so we get to those questions. All right, Barbara, we are glad that you are here on Open Line. What is your question for Kevin?
Yes. We are going to get to as many calls as we can in this half hour, our last half hour. So we get
and Barbara, if you can hear us, you might turn your television down a little bit, because that kind of has a little feedback for you, and it'll be a little more clear if you just do that.
Okay, thank you.
All right, go ahead, Barbara.
Hello?
Yeah, go ahead, Barbara.
Yes, sir. I have one question. I hate to ask this question, but unfortunately I have to. I lost my mom. I live in Nashville, Tennessee, and they live in Pittsburgh, Pennsylvania. I lost my mom 3 weeks ago. The oldest of 9. My mom did have a will. She left power of attorney to my niece because they live there. My niece in return has left it up to me and my brothers and sisters what to do with her house of 50 years and her belongings. Nobody's coming to agreement. Nobody wants to talk. Everybody's like asking like a child. With me being the oldest, she owes $146,000 to the bank for her home. She refinanced it. My question is that, do I legally, being her oldest, and we are allowed to do whatever we want, try to get a loan to pay the house off, or just the house should be just put up for sale, which my brothers want to do, and split it. I don't know what to do, because it's like I'm the outsider, which I'm not. I'm in Nashville and just had surgery. So I don't know if I have a right.
Yeah, I'll give you a little advice. You know, everything's going to have to be handled in Pennsylvania. That's where she was. That's where her home is. Now, if there was a will, they named an executor in that. And if that person is not doing a good job, not capable, gone for what, anybody, including you, can petition the court and ask to become the executor. They give everybody notice, and then the judge says, well, you're the most reasonable person and you're the most responsible. I'll make you executor. You got to get that done, because we can't sell the home until we have the power of the court to, because it's in their name. They have passed away. How do you get the deed from their name to your name? And if one of the brothers or sisters wanted to buy that home, hey, guess what? It'll still go to auction. That brother or sister can go buy it, and then the proceeds would be divided per stirpes on who was the siblings and who were the natural heirs. So again, what's my best advice? Take a proactive approach. Call an estate lawyer, see if they've opened, and if they haven't, then get your hands on the will and go do it.
All right, great. Barbara, thanks so much. We're glad that you called in. Great question. We are going back to the lines right now. So Tony is on the line with us. Tony, thanks for your patience. We're glad that you're here on Open Line. Do you have a question or a comment for Kevin? Can you hear us, Tony? All right, Tony, can you hear us? All right, looks like we've lost Tony. Tony, please call back if you can hear us. Now we'll go back to the lines right now, and let's go to Dan. Dan, good evening. Dan, can you hear us? Sounds like you're cutting out. Maybe the storms are wreaking havoc. All right, well, I tell you what, we are going to try Joanne. Joanne, are you on the line with us?
Yes, I am.
All right. Good. Do you have a question or a comment for Kevin?
Yes, I have a question. In my divorce decree many years ago, my ex is supposed to pay my funeral expenses, and I want to know how best to handle this. He is remarried.
Okay, so here's the real world. If you have a final decree, that is a court order. Now, the terms of that court order, the question is, was it specific enough that he is going to have to prepay that? He is going to pay whatever? And then there's a lot of gray areas. Quite frankly, you may have to ultimately either ask him and say, hey, this is what I want to do. I want you to pay for it. See if you're going to get some cooperation. He's not really under a court order to prepay it, but you never know what a judge would do if you had to petition the court to resolve a misunderstanding. You know, I have these final decrees all the time, and lawyers say, Kevin, you don't have to put that in there. I said, I know, but let's clear up any misunderstanding now, that he will pay for it. He will pay for it at this McReynolds Day Funeral Home. He will pay for the opening. He'll pay for the headstone, or he will pay up to $10,000. So I don't really know about your specific purpose other than you can try to call him and resolve it. If you've got family members, Daddy, you need to do this, and get Mother, let's solve it because we don't want a problem. Or get a lawyer to write him a letter or file a petition with the court, and it'll be closed.
All right, great advice. Thanks so much. All right, let's go back to our lines right now. All right, Joe, are you with us?
Yeah, I'm here.
Okay, Joe, go right ahead.
I first want to say that's a great pink suit.
Thank you, Joe.
I'm wearing a coral green suit, a shirt myself, and I want to ask about will investments. Can you hear me?
I got you. Go ahead.
Yeah, I called you back about maybe 2 years ago. You might remember Brian. I used to call him all the time. I've got this yellow page will. It's like the legal pad that I wrote out, and my father wrote out, and I inherited some property, remember, from Florida. I went down there, and there was this lady there in a trailer, and it was some frontage property, not worth a lot, like $80,000 or something. But now it's worth like $200,000, $300,000 to $400,000. And I got her out of it, and I live out in the country towards the west, like Fairview, Dixon and stuff. And now I've got this property. And I don't want to say I don't want to do it, but I'm writing up on a legal pad what to do. And I want to know if it's a great thing to do. And I know a couple of lawyers. I know the other guy named Kennedy, David Kennedy, and Mark McCluskey or something. I can't remember his name. I want to give him a plug on the TV, but I can't remember his name.
That's
right.
Anyway,
what do you think?
Okay, first off, thank you for the compliment on I wore this to try to give Chuck a little enthusiasm, get us some excitement going so we can get the power going. And number two, the Kennedys, they always have a good name. I remember when I got to be a lawyer, they said, always trust the Kennedys. I heard that, so again, that's something great. The name was given to me. Let's go to your question specifically. A legal pad, write it out. If your dad signed it and wrote it in his own handwriting, that is a holographic will, and it is legal and it is binding. Now, if his name's on that deed down there, if it's in Florida, you're either going to have to have that will probated where the land is, or if he lived in Tennessee, have it probated here. That's the way you get the court order to say, from his name to your name, you get a legal deed and you record that at the courthouse there where the property is. Then that gives you the right to sell it. You might get a title opinion and they say, hey, there could be a host of things, but I'd rather be in your position with that holographic will than without it. It's been said, it's better to have it and not need it than need it and not have it. Thank you so much. Appreciate your question.
Absolutely, Joe. We're glad that you called in. And it's always nice to hear from someone who'd called in a couple of years ago. Love that.
We've been here. Good gracious. I told you, Chuck was just a boy when we got started.
All right. Here we go. Back to the phones. I tell you, a lot of you calling. We appreciate that. Mike, you are on open line. Do you have a question for Kevin?
Yeah, I have a question on behalf of a coworker of mine, and good evening to both of you guys.
Thanks.
I have a situation where this coworker is at lunch, and different times when we're hanging out outside of work. He's got an issue where he got into a misdemeanor verbal disagreement with somebody, and basically they charged him with verbal assault.
Yep.
I think that was the case. And basically, because he had no other criminal background or anything, that they gave him an opportunity to do deferred adjudication. And basically, that means basically, I think his was like if he didn't get in trouble for a year, it would be completely wiped from his record.
Yes.
So when he went to court, the judge who was sitting on the bench, even though it's not a traditional trial, basically you say you agree to what the prosecution has worked out with you.
Yep.
But that judge is his best friend of his dad. He feels like that should technically, that judge who's his dad's friend should have recused himself. And what do you think about that?
Well, first off, I thank you for the question. And the rules that govern lawyers and govern judges says that we shouldn't even have a inkling of something that would not appear proper. So, but again, people will continue to serve in those capacities unless someone were to raise that. And then again, you can file a motion for a judge to recuse themselves. I've seen that. And that's a dangerous game we play. Chuck says, hey, I want him to recuse yourself. And I say, Your Honor, the client wishes to ask you to recuse yourself for this, this, this. And the judge can say, I respectfully deny that motion. Now bring Chuck in here and let's try him. Well, y'all can understand that's really not what you want. So again, let your lawyer evaluate the pros and cons. Thank you for talking about the pretrial diversion. In Tennessee, it's one of the greatest laws ever issued. If there was a misunderstanding, we put you on a pretrial status, 6 months, a year, no conviction. And then at the end, we can file an expungement. What does that mean? It means that Chuck had this, a misunderstanding. We went through pretrial diversion 6 months later. It's wiped off. It's not in the computer. It's not anywhere. And so that is a great thing. And if you find yourself that, or you're in a little county somewhere else, you might ask, I've never been in trouble. Can I get a pretrial diversion? And you never plead to anything. They also have what's known as a post-trial diversion. That's where I want to make sure Chuck pleads guilty. He'll plead, but it's never entered. So if Chuck acts up a month from now, all we're going to do is sentencing. But if it's pretrial, we'll have to try Chuck. Well, all the witnesses may be gone. They always say for a defense lawyer, a good continuance is a good thing because people do move and people get in trouble and their case falls apart. So that's some of the strategy that lawyers are confronted with. Thank you for your question.
Absolutely, Mike. We appreciate you calling in on Open Line tonight. We've got a lot of you still on the line with us. We're going to take a short break. When we come back, Nicole, you're up next. You are watching Open Line.